Hello, I'm Tom Cross and welcome to Cross Examination. I'm a barrister in London working on cases with cultural, moral and ethical importance. In this podcast, expert panellists join me to take an independent look at the law surrounding one of these issues. Dr Sarah Benn was a GP with an unblemished career who's become, in her words, terrified by the dangers posed by climate change and convinced that governments are not doing enough, quickly enough, to mitigate its effects. She became involved in direct action, a form of disruptive protest aimed at preventing others from carrying out lawful activities, joining the Just Stop Oil campaign in 2022. She went to Kingsbury Oil Terminal in the Midlands and on 3 occasions deliberately breached an injunction prohibiting protest over the site and adjacent roads, including by stopping tankers from moving in and out. In April this year, 2024, she was suspended by a Medical Practitioners Tribunal, not for protesting per se, but for breaching the injunction in contempt of court. The view of the tribunal was that the public expects doctors to be law-abiding. Dr Benn's position is the other way round. She asks, why would the public trust a doctor who chooses not to do anything meaningful, assuming their action is proportionate? Dr Benn's is far from the only case in which disruptive protest has generated legal process, both within the criminal courts and outside them. But few understand the complexity of the parameters of what is and isn't allowed. So when will protest be protected by the law as a legitimate form of free expression or assembly? And when can it be shut down, prevented, or even attract criminal penalty? Cross-examining with me, as ever, are 2 real experts on the topic. Adam Wagner is a barrister specialising in human rights, public law and public inquiries. He regularly acts for protesters and has acted in recent years in leading cases involving protests during the pandemic, including for the organisers of the Sarah Everard Vigil in their successful judicial review of the Metropolitan Police. He's also acted in a number of leading cases relating to protest injunctions. Hi, Adam.
Morning.
Francesca Cociani is a senior associate in the Criminal Defence Department at Hodge Jones Allen. She's heavily involved in the protest team, regularly representing protesters in both the Magistrates and Crown Court. And in the week before this, she represented one of the defendants charged with criminal damage from the Just Stop Oil protest at the World Snooker Championship at the Crucible in Sheffield last year, 2023. Hi, Francesca.
Good morning.
Francesca, let's start with the basics. Protests can engage what we call, as lawyers, criminal law and something called civil law. Let's start with the criminal law. What's the difference, first of all, between criminal law and civil law, and how does protest engage or involve criminal law?
So criminal law is usually aimed at preventing conduct that's contrary to the interests of society as a whole. Breaking the criminal law can lead to punitive consequences like fines, community orders, and imprisonment. Civil law, on the other hand, means non-criminal. In the context of protest, the civil law can be used to obtain, for instance, injunctions that prevent protest in particular places by particular persons. In the context of protest, there are several criminal offences that are relevant.
Yep.
The main ones being criminal damage, obstruction of the highway, aggravated trespass, or causing a public nuisance.
So criminal damage, one of, but not the only type of criminal offence that's engaged in relation to protest. And criminal law can be added to by amendments to legislation, as has happened quite recently in relation to protest.
Correct. And in fact, most recently, Parliament has introduced new criminal offences contained in the Public Order Act 2023, which now criminalise common features of direct action like locking on, tunnelling, or interfering with the use or operation of key national infrastructure.
What's locking on?
Locking on is when protesters use lock-on devices to either lock on to each other or lock on to a gate or some other sort of infrastructure to sort of block the entrance to a building or somewhere and delay the process by which the police is able to remove them.
So that wasn't, for example, something that was felt to be covered by existing criminal law. It was thought that you need to create a different offence to criminalise, rightly or wrongly, the people who are locking on. Adam, that's criminal. What about civil law? The main area is what we call protest injunctions here. What are they?
Yes, so a protest injunction is an order that the court makes when the person who's applying for the order is having their civil rights breached in some way. The classic or the most simple one to obtain is where they're having their land trespassed on, which is that an individual's on someone else's land without their consent, and they have a better right to occupy the land. But that's not the only way of getting an injunction. You can also get it if there's a private or a public nuisance, if there's harassment, which does sometimes happen in protest injunction contexts, or even breaches of the criminal law on that person's land. And what will usually happen, the sort of practical version of it, is that say an oil refinery is having protests in its entrance, and the protesters are preventing traffic going in and out of the entrance, and they're stepping across the line into the land owned by the oil company. If the oil company can go to court and show evidence of past breaches of sort of past trespasses, maybe harassment of staff, criminal damage to the some of the lorries, people jumping on lorries, that sort of thing, then they can potentially get an injunction. And the reason that this has become a sort of pretty formidable tool in the armory of oil companies, fracking companies, even shops, schools in some contexts, is that is something called a persons unknown injunction. In the law, when you claim against a person, the person is a person. So I go, Tom Cross is bothering me, is harassing me or whatever. I'm not saying you are, but if you were,
for the first time,
then I go Then I go to court and I say, Tom Cross is harassing me. Here's all the evidence. I want to stop him harassing me in future. And the court says, right, well, he's not allowed within 500 meters of your chambers or whatever. But about 20 years ago, the law changed to allow the idea that not only do you have to give an individual's name, you can actually just say, I don't know who this person or these people are. I want an injunction against anybody who's doing a particular act. So usually it'll be something like trespass or harassment. You don't have to name them at all. And so it's quite literally against anybody in the world and the definition of the person is that they're doing the act that's prohibited. But it's absolutely, and if you allow me to digress for 1 second, it came out of it's all J.K. Rowling's fault, because it came out of the original case was about Harry Potter and the Goblet of Fire. When the book came out, it was being counterfeited, but the Bloomsbury publishers didn't know who was doing the counterfeiting. All they knew is they were doing the counterfeiting. So they went to court and they said, we don't know who these individuals are, but can you give us an injunction which means that any time somebody counterfeits the book, they become in breach of this injunction? And the court said yes. And then a few months later, the same judge was faced with a protest case where a landowner came and said, well, actually, I've got the same issue, but instead of people copying books, they're trespassing on my land. I don't know who they are. And it was a case called Hampshire Waste. And the judge said, OK, well, fine. Well, I've got this new tool in the armory, which I created. And it was the vice chancellor, so it's a pretty powerful judge. Said, okay, fine, I'll give you an injunction, and it doesn't have to be an individual; it can be the description of the person. And it went from there. And since then, it's become a really, really common way of preventing protests.
It's a rather nice example of how the law often works, that you have a principle developed in some factual context, and then that same principle has been established. It can be applied in a completely different factual context, from Harry Potter to protest. What about, Adam, if you breach an injunction? People want to know about that.
So this gets into what looks to what would look to a member of the public a lot like criminal law. Because what happens when you breach a court order, which is what an injunction is you're in contempt of court, and the court can do either fine you or send you to prison for up to 2 years. And it's quite a weird area of law. And I do it a lot, and I do very little criminal law, but I do a lot of civil law, and this is somewhere in between. Yeah. It's neither it's kind of technically civil law, but it's kind of criminal law. And the judges are having to sentence people. They're having to think about things like their past record, their culpability. These are sort of criminal law concepts, but it's a very blunt tool, because unlike criminal law, there's no community sentences, so you can't make someone do a community order, work in the community instead of being, there's nothing in between a fine and a prison sentence. They can suspend the prison sentence, but it's it's really looks a lot like criminal law. It smells like criminal law, but it isn't criminal law, which makes it very, I think, quite sort of precarious for individuals who are caught up in it.
But fundamentally, you can go to prison for breaching an injunction. Further layer of complexity then, Francesca's talked about criminal law. Adam, you've talked about examples of types of civil law, trespass, nuisance, and so on. There's an additional layer, Adam, just sticking with you for the moment, as it were, that you can think about running alongside, if you like, these areas of what lawyers call domestic law. In other words, the law of the UK, the law specifically as we've described it in England and Wales. In other words, human rights law. And basically, the way the Human Rights Act works is it requires the court to consider the human rights of protesters alongside the laws, criminal or civil, that we're discussing here, and make sure that human rights are protected at all events. What are the human rights that are in play here? And what are they?
Yeah, so the three key ones are what we call articles, which are the sort of sections of the European Convention on Human Rights, Articles 9, 10 and 11.
Yep.
9 is freedom of thought, conscience and religion. 10 is freedom of expression, and 11 is freedom of association, which is really sort of the right to assemble and protest. So if you think of it sort of like belief, speech and action is the three. I mean, but they kind of they intertwine with each other. And the most important thing to know about them is that they're all what's called qualified rights. So whereas you're never allowed to torture somebody for any reason you can't justify torture, you can justify interfering with someone's freedom of speech or freedom of religion or freedom to assemble. And you can interfere if the interference is a proportionate interference with for a legitimate aim, and the aim will be something like, in this context, it will usually be protecting the rights of others.
Right. So in the case of these particular human rights, which is the case for all human rights, but in the case of these particular human rights, the court has to balance the nature of the right that is being the protection of the right that is embodied by the relevant article against some other interest which is being relied on as justification for interfering with.
Yeah, and so a classic example in this area is there was a case about protests outside of a school in Birmingham about it was about sex education. And the question for the court is, well, on the one hand, people have a right to protest, very important. They're doing it peacefully, but it's extremely noisy and disruptive for the children who have a right to be educated, and the parents have a right for their children to be educated. And that's it's a weighing exercise. And it always comes down to something called proportionality, which is the idea that you don't use a hammer to crack a nut, which is you don't do more than is strictly necessary to achieve the legitimate aim that you're looking to achieve.
So, Francesca, just bringing it back then to crime, someone is accused of a criminal offence. We're not talking about injunctions here. We're talking about somebody accused of a criminal offence. They come before the criminal courts. They might want to use, or have sought to use, certainly in recent years, human rights arguments to say I shouldn't be convicted or punished for this crime. How has that played out in the context of protest, I should say? Have these arguments been successful?
Yes. So the leading authority on this is the case of Ziegler. That was an obstruction of the highway case from 2017 at a protest against an arms exhibition.
Yep.
At the exhibition centre in East London. And essentially the court found that where Article 10 and Article 11 are engaged, the protesters can raise a defence of lawful excuse. That means that the proportionality of their conviction has to be considered by the court. And so where if it's for the prosecution to prove that a conviction for that offence would be a proportionate interference with their right to protest, so with their Article 10 and Article 11. And the court then goes on to set out loads of factors that are to be considered in that proportionality assessment. So, for example, the length of the protest, whether the extent of the disruption, whether there was prior notification, and so on and so forth. There has been several authorities since the case of Ziegler that have, in essence, further and further curtailed the application of human rights defences to criminal cases and in protest cases. And it's become more and more difficult to argue this.
Right, and it all started with Edward Colston's statue in Bristol, I think.
Yes. So what happened with the Colston case, that was a case of criminal damage. Protesters toppled the Colston statue in Bristol, and eventually they were acquitted by a jury at Bristol Crown Court. They raised a number of defences. And of course, with a jury trial, when you are acquitted, you don't find out for what defence the jury relied on. But what happened after that is that the Attorney General referred a question of law to the Court of Appeal, which is worth saying that it's something that's quite rare, actually. It doesn't happen very often that this is raised.
Right, because the government was particularly worried about the result, I guess. In Colston, they were particularly worried at the time that there was an atmosphere in society in which, as they would see it, people felt entitled to tear down statues. They didn't like that as a matter of policy, so they go to the Court of Appeal and say, what are the circumstances in which people can rely on human rights as a defence?
Precisely. And so the effect of that is, the defendants, they remain acquitted. The outcome of that Court of Appeal judgment has no effect on their conviction, but it did have the effect of significantly limit the application of Article 10 and Article 11 defences to criminal damage cases. The main finding was that whilst criminal damage is not an offence in itself that does not require an assessment of the proportionality, such as other offences, each case turns on its own elements. And for instance, where violence is involved or where weapons are involved, there is no circumstance under which you can rely on Article 10 and Article 11. There is also no circumstance where the damage caused is significant damage to property. They say that will fall outside the protection of the Convention. They go further than that, and they, somewhat controversially, they draw the distinction between public and private property, essentially stating that where the damage is minor or temporary, in public property cases, there will need to be a case-specific assessment of the proportionality. But then they say that that significance threshold is likely to be reached far below the magistrates' court divide, and so that's £5,000.
This is almost the Court of Appeal drawing a line. They're not quite saying that you can never run a human rights argument, no matter the nature of the damage in the context of criminal damage that you cause. They're still allowing the possibility that a defendant in a criminal damage case can still say, all I've done is so minor that I should be allowed to argue that it's disproportionate to convict me or to punish me. But the circumstances in which the Court of Appeal is saying you can do that as the defendant are really very limited indeed.
They're very limited, and they're even more limited where damage is carried out to private property. Right. But they go on to say that they can't imagine, they can't possibly conceive that convention rights could be used where damage is anything other than trivial, making it extremely difficult, therefore, to raise that.
Protesters, Adam, would see that, at least in the criminal context, as an erosion of human rights. If we think about the civil law and protest injunctions you were talking about before, to what extent does human rights law still loom large in the arguments in those cases? Is there this distinction, for example, I wonder, that Francesca refers to them drawing in the Colston case between public and private land?
Yeah, I mean, they loom large in the cases that I run, but not always successfully. I mean, it's a real moving target, and it's not easy bringing in human rights to these cases, because quite often, I mean, talk from a personal perspective, quite often the courts see breaches of court orders as really, really serious. And obviously they see any breach of anything seriously, but they take it as a sort of almost like a personal affront against the rule of law. And so you're much better off bringing in human rights at the stage where the injunction's granted. But the problem is that usually you're not there. The protesters don't generally make arguments there. There's no funding to do it. You can't get legal aid funding to do it. Yep. So it's, I mean, I can say I've acted in lots of contempt cases, but only one case where I'm actually there at the source, which is their actual injunction. And it was really useful being there at when the injunction was being granted. But it was just happened to be there was some crowdfunding available. You know, these are really complex cases, and they're very difficult to do without any funding.
Right, that's interesting, because that is the very time when the court is, in principle, drawing the parameters as to what is acceptable and not, including from a human rights perspective.
Exactly. But on the other hand, the injunction, I talked about the Harry Potter case, that the injunctions over the last 20 years, the extent of them has massively increased. So you've gone from a waste site in the Hampshire waste case to, a few hundred, I think 100 metres or even less outside of a shop in the Canada Goose case. I think the first case I acted in was the Quadrilla case, which was basically the mouth of the entrance of a fracking site and also the road that came into it to prevent obstruction of the highway. But then the last 2 or 3 years, you've seen injunctions that cover the whole country. So that the National Highways case, which was about Insulate Britain protests on the highway, it literally covered the entire what was called the strategic roads network. So all of the major roads in England were covered by this monster injunction, which said you cannot protest on any major road without breaching the injunction if you're going to obstruct traffic effectively. And that is, if you actually think about I think of those as effectively criminal laws. When you get onto private land, it's extremely difficult to use human rights I think the courts have actually gone too far on that, because I think what Strasbourg says is that you will always be, even on private land, you engage your human rights. It's going to be very easy for the state to justify an interference on someone's private land, because you're not really allowed to protest on someone else's private land. So that's usually fine, but it's still a human rights issue. It's just a lower order. But on public land, that's where all the action is in the European Court of Human Rights, on public roads, in public squares, because that's where protests happen. Yeah. Protests are no good if they're in your house, or they are, in a room somewhere where no one can see. The whole point is you're out there showing people, talking to people about your cause, showing it. You are disrupting people in order to tell them something. You're speaking to them, the public. So in the public space, if the courts are saying actually it's fine to injunct entire city centres or whatever it would be, I think you do question what's the point of the human rights protections there. And then when you get to the contempt phase, there's lots of ways human rights. So I've done lots of work on the clarity of injunctions. So I'll always, not always, but I'll often raise that in cases because they're often not very clear. They're drafted by a lawyer who then takes them to court without being contested. So the difference between that and a criminal law which goes through Parliament is, you can imagine, pretty vast. But the problem is, the courts will often say, maybe it is a bit unclear, but you should have challenged it at the time, shouldn't you? And then you're back in that
Which gives rise to
circle.
The same problems that you mentioned before. Is it really realistic for a protester, may by the way not know at the time the injunctions impose that they want to protest in the future, to go along to court with all of the difficulty? You can't get legal aid. You don't know whether you're going to want to do it in the future and so on. Let me come back to that in due course. I want to bring in Dr. Sarah Benn in a minute, Francesca. But before we do, we should say something about professional discipline law, which I suppose is technically part of civil law, but it's a bit different from the general crime and the protest injunctions we've been talking about. This is the law, isn't it, which governs the specific standards applicable to certain professional people, for example, doctors, lawyers, and so on, arising out of the fact that they're professionals.
Correct. There are specialist standards for the different professions enforced by regulators, and often a tribunal which is independent of the regulator. So in the case of medical practitioners, it's the General Medical Council that can bring cases before a tribunal called the Medical Practitioners Tribunal. And there are similar setups for other professions, for example, including solicitors as well, will have their own tribunal. What the professional standards regimes tend to have in common is that they require professionals, through their conduct, to maintain public confidence in the profession. That's a sort of key test. And what that may require is something which can change over time.
Right, so the sort of golden thread that run through these tribunals or these codes, these regimes that apply to professionals, is the professional is expected to maintain public confidence in them as a professional. And that gives rise to the question, if I protest, perhaps if I protest in breach of the law, perhaps if I do so knowingly in breach of the law, will the public's confidence in me still be maintained? Let's have a listen to Dr. Sarah Benn. She's a GP who's become convinced of the need for doctors to take direct action to draw attention to the dangers of climate change and to encourage more urgent action to tackle it. I spoke to her before the Medical Practitioners Tribunal, which she faced in April this year, 2024, and started by asking her about the nature of her beliefs, which had led her to engage in disruptive protest.
We are, as doctors, we're trusted messengers. We've been trained in science, we've been trained to evaluate evidence and to act on it. We're also in quite a privileged position in society. We have a duty to speak up if we see something that needs action taking. It's like if I make a safeguarding referral for, say, a child at risk or something, it's not enough to just submit a form or make a telephone call and put a tick in that box. If nothing is happening, then a doctor has a duty to chase it up and do something and keep doing something until the relevant action is taken. So I spent much of my adult life sort of worrying quietly about what's happening to the world, and trying to sort of do what I could to shrink my own impact, my own sort of personal lifestyle choices. But I was never an activist. I never kind of really looked into that beyond sort of supporting Greenpeace and the Green Party, that kind of thing. In 2019, I came across Extinction Rebellion, and I watched their video and thought, wow, that's a neat idea. Non-violent direct action, forcing change through disruption. What a brilliant idea. It's not something I could do because, I can't break the law or do anything like that. I'd be in real trouble. And then over a period of perhaps a few weeks, it dawned on me that if I didn't do something, if not me, then who? And then I kind of dived into it, and mostly did stuff. It was all kind of non-violent and mild to moderately disruptive. A lot of sitting down in roads. I glued myself to a couple of things like the door of a government building. As I say, just causing some mild or moderate disruption. So yes, I came across the Just Stop Oil campaign early in 2022, went along to a talk about it, and to me it was just a no-brainer really. I went to Kingsbury Oil Terminal, which is close to where I live, and a High Court injunction had been set up around the oil terminal, which prohibited all protest over the whole site and adjacent roads. And I deliberately broke the injunction on several occasions, 3 occasions, by firstly simply standing with a placard on a grass verge outside the oil terminal on a public road, but just by the fence of the terminal, but also sitting down in the entry road to the terminal with a banner and a placard and stopping tankers moving in or out of the terminal. That, as I say, that was a breach of that injunction. So again, it was sort of targeting the polluters, the oil terminal, as opposed to just disrupting the general public. So that really appealed. The injunction was to stop all protests in that area, even something as simple as standing with a placard, drawing the attention of passing motorists, members of the public, to our campaign, that situation could be set up so that somebody just standing with a placard like that, shouting out an alarm about the situation, that could land somebody in prison, I think is utterly outrageous. and not what laws and the legal system are for. And an injunction is a bit of law that's been sort of bought to silence people. And that does not seem right or proper to me. It's completely disproportionate considering the amount of disruption that we actually caused, which was very small. I feel that my misconduct, in inverted commas, is so trivial in the context of my motivation, which is all about saving life and health and so on, that I'm not sure it amounts to professional misconduct at all. If it does, and I accept that, I've broken the law, so if this misconduct, if this does amount to professional misconduct, I totally reject that it impairs my fitness to practice as a doctor. The reason I've ended up in the situation of a tribunal is all about paragraph 65 of good medical practice, which says that my actions must always justify the trust of patients and the public. And I would ask, why should my actions in shouting about an emergency and what needs to be done, why should that undermine the trust of the public? When I think about, maybe me as a doctor dressed in scrubs handing out leaflets about climate change on a high street, and I've done that, a few people will stop and have a chat, and that's good, that's important. But if I as a doctor am sufficiently concerned, change that to sufficiently terrified, that I'm prepared to break the law, go to prison, get struck off, I hope, and maybe it's naive, but I hope that a few more people might take notice.
Adam, let's start by thinking about Dr. Benn's case legally. What sort of factors at the injunction imposition stage will the court take into account in your experience? What will weigh with the court in deciding whether or not to grant one of these injunctions in the first place?
The court will be extremely careful generally in making sure there is past behaviour which justifies the threat of future behaviour. In a successful injunction application, what you'll often see is quite a detailed dossier of incidents on and around the site. Say if it's about a site, so you'll see, that on all of these dates the fence was damaged, and people came in and out. There'll be video evidence. It will always be an interim injunction to start with, so it'll be an urgent interim injunction, which is a sort of middle ground between nothing and a final injunction. And that's usually what they're looking for. And when that evidence will be weighed, will be put on the scales against the legitimate lawful right of individuals to, say, stand outside the site with placards, speaking to people, giving out leaflets, doing things which are ordinarily totally lawful and normal protest behaviour.
What about the nature of the argument that a protester might want to make? I mean, Sarah Benn wasn't there at the time that the injunction was imposed by the High Court. As you explained earlier, seldom actually will the would-be protesters be there at the time that the imposition is imposed by the High Court. They don't know that they want to protest, they haven't got the money to contest it, and so on and so forth. Is the nature of the issue that people might want to protest about, which is at the heart of why Sarah Benn explains that she did what she did, something that the court, first of all, can take into account legally or does in practice?
They do take into account the cause, but it's a pretty simple analysis, because it's effectively saying, are they protected or not by these human rights? So any cause that is a sort of mainstream political cause, animal rights, environmentalism, parents protesting against sex education, those are all clearly within the boundaries of freedom of speech, freedom of association. Whereas certain causes like protesting against black people being allowed to work or something like that, which would be very clearly fall outside of the convention protection, because any cause which has in its effect destroying other people's rights does not fall within the protection of the convention. The court will say, yes, we can see it's clearly a serious and important cause for these individuals and for society widely, but they don't really go much further than that, and they shouldn't go further than that.
What about, Francesca, the professional discipline, the professional obligations element to Sarah Benn's story? Because that is, after all, the nature of the proceedings that were taken against her. She says that she totally rejects that her conduct impairs her fitness to practice as a doctor. It's nothing to do with the way she treats patients or how well or otherwise she treats patients. She says, what I'm doing is I'm shouting about an emergency. She says, why should my actions in shouting about an emergency undermine the trust of the public in my work as a doctor? Why would you trust a doctor, she says, who chooses not to do anything, albeit, she adds, in a proportionate way? The tribunal in this sort of case is acting, it seems to me, to some extent necessarily as a reflection of public mood. What do the public make of something? I wonder how far you feel in the criminal courts specifically the approach of judges or juries reflects public mood. Are there any trends or shifts that you've identified in recent times?
Well, so taking a step back, of course, public mood and the government's stance in relation to any issue, including protest, will feed off each other, largely through media and tabloids, but in a myriad ways. And that will ultimately influence the laws that are passed. For example, the Public Order Act 2023 has redefined the meaning of serious disruption to more than minor disruption. And that is one example. And so when we look at the criminal courts, ultimately judges, they are bound to apply the law. But I think it's hard to imagine a system, their system, functioning in a way that is completely insulated from what happens outside the courtroom. And then if we turn to juries, juries, it's a system that relies on 12 random members of the public that are chosen completely randomly. And of course, at the start of each trial, they are directed to leave all their prejudice outside the courtroom or any preformed idea, etc., and to solely focus on the directions that they're given. But it's hard to believe how 12 random members of the public would be able to exercise their judgment in a way that is completely removed or insulated from what happens outside the courtroom.
Well, it's meant to be said to be often to be one of the strengths of the jury system is that actually you have a public that is reflecting society general rather than representing the views of the potentially inward-looking legal community. Trudy Warner's case, Adam, recently, this was somebody, perhaps you can explain, who stood outside of the courts reminding juries of their right to acquit defendants in accordance with their conscience. And when it was suggested by the Attorney General that she might be the subject of contempt proceedings, the court cleared her. You can do that. You can remind juries of their ability to act exactly as Francesca mentions, reflecting of society's views rather than what the judge necessarily may be steering you to do.
The court didn't just the court didn't just reject the application for contempt; it absolutely smashed it and said this is, there's absolutely no justification for this. And I think there's actually, that case is interesting from a contempt perspective, the law of contempt, but it's even more interesting, I think, from a psychological perspective of what's behind that application and what's behind her standing outside the court with that sign. And the answer is that juries are relatively often acquitting environmental protesters who quite often don't have lawyers and decide to directly speak to the jury and say, this is the cause. And it's causing absolute, chaos in a way in the judicial system, because judges are more and more saying, well, you're not allowed to talk to the jury about your beliefs, which itself is problematic, potentially, because what else are they there? It's sort of strange that it's not the context of what they're doing. If you listen to Dr. Benn. That's what it's about. She's not there just because she doesn't like court injunctions. She's there because she thinks the world is on fire and needs to be. There's only so long before we can put it out. So the juries are acquitting individuals even when they have, on the law, probably committed crimes, even when the crime is made out. The people are standing outside the court reminding juries that they can do that, and the Attorney General is saying that's outrageous. How can they do that? But in actual fact, that's a traditional thing that juries can do, and it creates a huge tension within the justice system about what the purpose of the criminal law is. Is the purpose of the criminal law
right
a kind of quite narrow purpose that there are laws passed by Parliament, and if they are breached, the juries must convict? Or is there, like you say, a wider mood of the public, like George Orwell said, if in a society where and I'm paraphrasing here, if the public want freedom of speech, there will be freedom of speech, and if the public don't want it, there won't be, and it doesn't. The sort of laws come second. And he was talking, I think, about a protest case.
Are we getting to the nub of the issue here, which is really about the rule of law? Whatever society thinks, lawyers are brought up, aren't they? Aren't we hardwired as lawyers to believe in the gospel, as it were, of the rule of law, and courts and judges even more so? The idea that nobody should be above the law or feel themselves entitled just because they think they're right on some issue, no matter how strongly they believe it, to take action that they know is against the law.
Yep.
You have that hardwired, it seems to me, principle within the legal community rubbing up against these wider societal views. You see it in Trinity Morning's case, but you see it in all of these. Criminal proceedings, Francesca, you may see it in where civil protest injunctions are contested. You certainly see it in the professional discipline context. In reality, that the courts are resistant to it, but the public may be resistant to the courts, Francesca.
Well, I think in terms of whether the protesters acting in a way that places them above the law, I think that's often a misconception that is amplified by the tabloids, amongst other things, that protesters who are caught in the criminal justice system act as though the law does not apply to them. If that were true, they would not be engaging with the system to begin with. We would not have this plethora of case law that arises out of protest cases. Quite the opposite, in fact. Many litigate their cases in a court of law because they want to show that if true justice can be made, then they should be found not guilty. Because of, amongst other things, the various reasons underpinning why they've taken those actions. But then I think we circle back to Dr. Benn's issues and sort of the cognitive dissonance that she struggles with, where on one hand, how can it not prevent the harm that the climate crisis is causing? If someone's got to do something and it's urgent, but unfortunately it's not quite the way that it's seen in the criminal courts.
I wonder, I put this to both of you, I wonder what your sense is each of, as it were, how well the law is doing in balancing cases which, let's face it, do almost always involve a certain balancing of interests, rights, and so on. Is it coping, Adam? Where's it going?
I think the courts are finding it really tough. And one of the problems is the goalposts are moving quite regularly with the law. The laws are changing often. We can talk about that. I think the other thing is that this tension is a pretty standard tension in societies where protest, large scale political movements often give rise to these problems. So if you look at the suffragettes and the suffragists, they were slashing paintings, they were throwing bombs, they were setting fire to things, they were violently protesting, they were peacefully protesting. It was an enormously disruptive and complex movement that people look back on now and say, well, generally, that was kind of justified because I mean the movement itself and the cause was justified. And I think morally, we as societies that are meant to be founded on the rule of law, those are issues which don't have a clear answer to me. You know, listening to Dr. Benn, you probably would, if you listened, if there was a podcast with Emmeline Pankhurst, you'd probably hear similar kind of thoughts. And people thought at the time, people were very, very angry about the suffragettes, and the suffragists particularly, and about the way that they were going about things. And you see the same with the civil rights movement in the US in the 1950s and 60s. You know, a lot of behaviour where they came into serious conflict both with police and with courts. And I think in terms of I think one mistake is to think that the rule of law and these protest movements are inherently in opposition, because I don't think they are. I think they sometimes are, but they're not always. And sensitive judges appreciate that. So there was a case that I did called Quadrilla in the Court of Appeal, where Lord Justice Leggett, as he was then, talked about civil disobedience. And he said, I'm just going to read from it. He said, civil disobedience may be defined as public, non-violent, conscientious act contrary to the law, done with the aim of bringing about a change in the law or policies of the government. When these conditions are met, such acts represent a form of political protest, both in the sense they're guided by principles of justice or social good, and in the sense they're addressed to other members of the community or those who hold power within it. And he said that in those kind of cases, there are reasons for showing greater clemency, because the people do it. They know what they're doing. They know they're breaching the law. They do it for a good reason, as might be described. And that puts them into a different category to someone who, say, breaks into a house to steal so they can sell stuff and make money for themselves. It's a completely different kind of situation. And I think in that the tension there is being, at least it's being understood and addressed in a way which puts these protesters in a different category to other criminals or other people who have committed crimes. I mean, there's no I think there's a sense of that in Dr. Benn's case. I think if the crimes that she committed had been, you know, for personal for personal wealth, or for, you know, or she'd been scamming somebody or fraud or something like that, I think she would have been struck off. I think the 5-month suspension was in a way quite lenient. Although I've not done professional discipline for a long time, but I suspect that if it had been a different order of crime, without that, they didn't say it, they didn't talk about it in the sense that Lord Justice Leggett did, but I think that the sanction itself, it was reasonably lenient. She's allowed to practice again, even though she's deliberately broken the law and she's gone to prison. Major things for a doctor to do. So these are the courts dealing with it? They are dealing with it as they can, and sometimes they do it better than in other times. But these are really tough issues.
Francesca, let me give the final word to you. What do your clients say about the law when they come to you and you have to explain to them what the nature of it is that the prosecution has to prove, but also the defences that may or may not be available to them? Do they, without getting into the specifics of what any particular client is, do you have a sense that there's a situation of vicious cycle going on where laws are passed, laws are increasingly passed to, for example, as you mentioned earlier, create new offences, and it isn't necessarily, I say calming, calm might not be the right response, but it isn't leading to a situation that is more globally in everyone's interests for the purposes of debating the sort of things that protesters want to ensure are debated and brought to the fore in the public conscience?
Well, yes, I think often there's a sense of disbelief and shock at the reality of the law that is before them, as we heard from Dr. Benn. It's difficult to fully grasp the fact that certain peaceful acts are more and more being defined as unlawful and preventing the use of defences with Article 10 and Article 11. And it's, very difficult to reconcile that with often the subjects of their protests, because, we can't lose sight of the fact that ultimately we're looking at climate protesters, for instance. They are protesting because they are looking at the science that the government has access to, and I think broadly agrees with, that says we have no time to change our ways, and you need to put measures in place that will ensure we don't end up where the science says we will end up. And facing a situation where those in powers aren't doing that, then individual members of civil society feel like breaking the law is the last resort. And I think, sort of also going back to the sort of increased curtailing of Article 10 and Article 11, I think we risk losing sight of the fact that ultimately we live in a democracy, and civil society and protesting, they are a fundamental pillar of democracy. Causing disruption is part of democracy, and that's why it's protected by European law and by domestic law. And so there is a real risk that if the government carries on in this direction, we're going to lose complete sight of where we actually started from, and what our values are in terms of living in the liberal democracy that we're supposed to be living in.
Well, I know that you represent the clients that you refer to as seeking to embody those values with great skill and experience. And Adam Wagner and Francesca Cociani, thank you very much for cross-examining with me today.
Thank you.
Thank you.
We've reached the end of the podcast, but we'll be back soon, and we'd love to know what you'd like us to examine next. Tell us what you're interested in or concerned about in the world of law by tweeting at CrossExaminPod or by visiting our website. That's www.crossexamination.co.uk. Remember to follow us wherever you get your podcasts, and if you've got time, we'd love a positive review on Apple Podcasts. It's the best way to spread the word about cross-examination. Meanwhile, I've been Tom Cross, and until next time, goodbye.